Counsel, those numbers show that Omicron is as deadly and causes as much serious disease in the unvaccinated as Delta did. The numbers, look at the hospitalization rates that are going on. We have more affected people in the country today than we had a year ago in January. We have hospitals that are almost at full capacity with people severely ill on ventilators. We have over 100,000 children, which we've never had before, in serious condition, and many on ventilators. So saying it's a different variant just underscores the fact that without some workplace rules with respect to vaccines, or encouraging vaccines, because this is not a vaccine mandate, and requiring masking, and requiring isolation of people who have tested for COVID. Because none of you have addressed that part of the ETS is to say something that should be self-evident to the world, but is not, which is, if you're sick, you can't come into work. The workplace can't let you into the workplace, and you shouldn't go on unmasked. Tell me what's irrational about rules of that nature when it is the workplace that puts you into contact with people that will put you at risk.
I don't know that we've argued that the requirement is irrational, and indeed, there may be many states subject to their own state laws that could impose this themselves, or private businesses. So we're not making...
So if it's within the police power to protect the health and welfare of workers, you seem to be saying the states can do it, but you're saying the federal government can't, even though it's facing the same crisis in interstate commerce that states are facing within their own borders. I am not sure I understand the distinction why the states would have the power, but the federal government wouldn't.
The federal government has no police power.
Oh, it does have power with respect to protecting the health and safety of workers. We have accept the constitutionality of OSHA.
Yes, I think you'd be asking if they had a police power to protect public health.
No, they have a police power to protect workers.
I would not call it a police power. I think their Commerce Clause power allows them to address health. Sorry, is there a question? It allows them to address health in the context of the workplace.
Exactly.
It's a good time to move to our sequential.
So let me give you a hypothetical. State court denies testing on one ground. Party, you have taken the position in your brief that the accrual should be from that decision, correct?
Assuming that that ground is a constitutional violation, yes, Your Honor.
All right. Now, they go up on appeal, and there was no appeal there. They go up on appeal, and the appellate court in Texas says they were wrong on ground one, but they were wrong, but they were right on an alternative ground. And now you say the plaintiff should appeal from when? He should have appealed from the first decision, or now he should appeal from the second, or both?
If I understand correctly, Your Honor, so we've got a trial court that imposed one unconstitutional condition. And
he should have appealed then, that's what you're saying.
Well, if there's, I assume because the appellate court's involved that he appealed that first judgment. Or
No,
are you
let's
saying
say,
that
he does, are you saying that him appealing stays the time he has to file a motion?
No, Your Honor. He can go immediately to federal court on whatever the unconstitutional
Let's assume he does what the state tells him, does a timely appeal. If he came to federal court in the middle of that appeal, would you argue that he doesn't have a viable claim yet?
No, Your Honor.
The appellate court hasn't decided this issue constitutionally.
Certainly not, Your Honor, on the assumption that his claim is that the trial court's decision included some condition that violates due process. Let's say this non-contamination.
The same as here. And so you're saying, what should the federal court do? Should it stay and wait until the appellate court says yes or no?
It need not, Your Honor. I might point out for practical purposes, for specifically Mr. Reed's claim, even had he waited past rehearing, even had he waited past certiorari being denied, he still had about 10 months left on his 2-year clock. So
I
the
know,
idea
you're claiming he was dilatory, but putting all of that aside, you still maintain that there's some practical importance to not letting him not exhaust, but go through a pending appellate process?
He may, Your Honor, if he wishes, but if he's already suffered a constitutional
And so now the
violation-
federal court should wait or not wait?
It need not, Your Honor.
But it can.
If parties request that it wait, that would be on a
seems like an
case-by-case
awful
basis.
waste of time.
But, Your
Thank you.
Honor, the idea that there would be a freestanding stay or freestanding essentially pause on the accrual of 1983 actions merely because there are similar topics and issue in state and federal court is exactly what this court rejected in Wallace.
Mr. Clement, salary basis. I think of salary basis is what am I paid for the week? I think of fee, what am I given as an amount? I think of hourly or shift in their ordinary meaning. What am I paid for the hour? What am I paid for the day? Your reading of this takes out basis completely. You're thinking that if I work an hour and get the minimum, that's my salary. But I read 602 and it says, receives each pay period on a weekly or less frequent basis a predetermined amount constituting all or part of the employee's compensation, which amount is not subject to reduction because of variations in the quality or quantity of the work performed. So you're requiring an hour of work or a minute of work, but that's not what the regulation says. The regulation says, what are you paying me for the week?
Well, what it's saying is that it's a predetermined amount that can't be subject, as you say, to reductions for the quality or the quantity of the work. And that perfectly describes the $963 that this worker was guaranteed in a week. Now, he can make more on top of that, but that's not the concern of this regulation. That's additional compensation.
What do we do with the second part of purpose of 602, which is to ensure, I thought the reason for 602 was to ensure that an employee who wanted to take a Friday afternoon off wouldn't be penalized, or wanted to do something else, or didn't want to start on Monday, but on whatever day they wanted to start. These employees don't have that discretion. They're not paid for any hour they take off. They're not paid for any part of a day they miss. So how does that fit the question of a salary basis?
Again,
Or how does that fit the definition of a salary basis?
I think, with all due respect, I think the problem is the 601 doesn't ask, is this employee primarily paid on a salary basis? It doesn't ask whether they can take a day off and how it will affect their pay.
But you tell me 601 says you have to fit 602, that 602 is incorporated.
But only for a very limited purpose, which is to figure out whether total annual compensation includes at least $455 a week paid on a salary basis. And then if you go through 602, 602 does not address the concern that your salary, your guaranteed amount is too low vis-a-vis your total compensation. That's addressed, if at all, only in 604.
Exactly. And so
Right.
what you're asking us to do is take an hourly wage earner and take them out of 604 and take them out of 604, which is the only provision that deals with someone who's not paid on a salary basis.
So with respect, I'm not asking you to do anything in particular with an hourly worker. The people who our position will affect.
This guy is an hourly worker.
Well, he's a daily worker.
Well, daily or
And-
hourly, but
and-
he's not a weekly worker.
His
Meaning
pay-
only
his
if he
pay-
decides to stay. That
His pay is calculated on a daily basis, but our position affects two classes of people, just to be clear. There's a class of people, and respondent is prototypical, who have a day rate that's above the weekly minimum that's specified in 601. There's another group of worker that's really the second half of the circuit split, and this is the Anani case from the Second Circuit and the Litz case from the First Circuit. And these are individuals whose pay is calculated on an hourly basis, but they're given a minimum guarantee on top of that, $1,000, $2,000, whatever it is. And I think if you go through the regulation and look at what 602 requires, you would see that whether it's a person whose daily rate is above the weekly minimum or somebody who gets that kind of weekly guarantee, they satisfy the terms of 602. Again, 602 doesn't say, are you generally paid on a salary basis? It has a definition of salary basis that allows you to answer the question that's relevant under 601.
Would get an automatic plus for checking a box?
No.
That's the whole point, isn't it? That checking the box is not what gets you a point.
Right, right. And I think, one helpful illustration of this point, Your Honor, is so SFFA's own expert, their own deciles analysis finds that among the most academically qualified students, Asian Americans and white applicants actually have a higher acceptance rate than black students. This is their own expert evidence, and this is discussed at PEDAP 78. As the district court commented, that is a particularly strange result if their characterizations of our admissions process are accurate.
Mr. Park, on this issue of when this will end, 9 states have chosen to rely just on race neutral, completely race neutral, with race being not even a small factor anywhere. Not all of them have been as a result of the people voting. It's been the systems themselves choosing this. Isn't that the case in Florida?
That's my understanding. In Florida, it's an executive order, and there are many states where it's institution by institution. So Georgia, for example, is...
Now, even your adversary said he didn't see the 25 years as a set deadline. It was an expectation. What we know, we have 9 states who have tried it, and in each of them, as I mentioned earlier, white admissions have either remained the same or increased, and clearly in some institutions, the numbers for underrepresented groups has fallen dramatically, correct?
That's my understanding, yes.
All right. What we also know in those 20-odd years is that racial disparities has grown dramatically as well. Segregation has grown. The disparity between incomes has grown. And so has the effects of these things in terms of the resources that underrepresented groups receive, correct?
I believe that that matches much of my understanding, yes.
And I understood that the district court found that UNC, on a continuing basis, reassesses its race-neutral factors and is constantly monitoring whether they've reached some form of representation adequate for their system regularly, correct?
Yes, yes. And
that was your point, which is we can't tell you it's going to end in 2029 or 2030, but we're not just assuming it will continue. We're looking at it regularly to see when it ends, correct?
Exactly, Your Honor. And there really is a quite extensive infrastructure that the university has established to continually monitor our progress on this score. A whole range of committees, but the committees actually include some of the world's leading experts on doing these kinds of qualitative assessments. And so it's something that we are continually pursuing. And right now, there are many other projects ongoing for us to try to reach the day where we can find a viable race-neutral alternative.
Thank you, Counsel. I'm a little confused because this almost sounds like a different kind of viewpoint discrimination. And under our strict scrutiny standards, we're not supposed to discriminate on the basis of viewpoint or discriminate on the basis of religion. They're considered as sacrosanct, I believe, as race. And yet what you're suggesting is that the viewpoint that somehow being a minority that overcomes discrimination in the way you define it as important, as overcoming obstacles, that's okay. But if you're a black person who's from an affluent family, who may be the only class president ever in a white school's history, that fact shouldn't feature. That's a form of viewpoint discrimination, isn't it?
I don't think we're saying...
That's not overcoming any kind of obstacle?
We're not saying that universities have to consider anything or nothing. Universities just cannot consider race itself.
But I thought you were saying that both of those essays might be entirely appropriate for the university to consider. Is that correct?
Correct,
Or did
yeah.
I misunderstand what you were saying?
No, there is no federal statute about what essays universities consider. There's a federal ban on consideration of race
So
itself.
why is it, are you just objecting to touching a box that admissions officers can look at?
We're objecting to the use of race as either a plus or a minus in making
But I don't
admissions
think you,
decisions.
I think the district court made very clear findings that checking the box alone is not what got anybody in. That
There's
it was a holistic enterprise that looked at everything that that candidate did, and race might have been one among many factors. Because there's a lot of Hispanics and blacks who have higher GPAs than so many whites who don't get admitted. So they're not looking at just being black and white. They're rejecting a lot of the 10% applicants who have higher numbers than, I guess, whites and Asian Americans.
Your Honor, there's a finding from the district court in our favor at page 116 of the petition appendix that Harvard can award a racial preference based on the checkbox alone, whether or not an applicant writes about it or otherwise indicates that it's important to them. And that is important. That's race itself.
That finding was made in an undisputed finding by the district court that race alone did not account for any one admissions package, that it was race among many factors.
Well, the district court found that race is determinative for 45% of blacks and Hispanics who get into Harvard. So, yes, there's 55% who would not get in.
I'll let Mr. Waxman debate that, because that's not the way I saw that record. It was very clear that the district court found, for example, that being Asian or not being Asian wasn't involved statistically in any amount, in any of the admissions, whether for ADLCs or for non-ADLCs.
Well, I just want to be clear. The 45% number is when race is determinative for blacks and Hispanics. That's the number of applicants who it's determinative for. Our number was much higher. That's not my number. That's Harvard's number in their race-neutral alternatives report.
Sorry, but many of the civil rights statutes and some of the laws pertaining thereto were directed to being equal to whites. So there was consciousness of race in those statutes.
I think not in a relevant sense. Those statutes, this court said in the JAM case in 2019 that exact language is colorblind, that whites, you have to have the same rights as whites, which means everyone is equal. Now, they used race-based language, but what they did was they banned racial discrimination.
So
That's
what
not
do
race
we
consciousness.
do about all the legislation that was passed that gave benefits not just to former slaves, but to free blacks? That was still remedial in your mind? Because there was inequality, correct?
I believe it was. It was in response to an entire system that had been built up of de jure discrimination. I think those were remedial statutes as well. And
So even if we have de jure discrimination now or segregation now, Congress can't look at that? Because we certainly have de jure segregation. The races are treated very differently in our society in terms of their access to opportunity.
I believe that the remedial exception is still good law. It was one of the two things that justifies the use of race in education that this court identified and parents involved. However, Harvard has not made that argument, has no factual record that you would need to support that argument. It does not justify its use of race based on its own prior discrimination against blacks and Hispanics.
Are you aware of de jure segregation today?
I am not. I am aware that racial preferences on college campuses, in our view, have increased racial consciousness, and so there's some of this is happening on campus, but it's not de jure.
It's not clear that there's segregation between there are large swaths of the country with residential segregation. There are large numbers of schools in our country that have people of just one race. There are districts that have only kids of one race and not multiple race or not white people. De jure to me means places are segregated. The causes may be different, but places are segregated in our country.
Absolutely. I think the top 10% program in Fisher, which really got a bad rap in Fisher too, but was meant, solutions like that are meant to account for residential segregation in a race-neutral way.
Yeah, the problem is that they don't. That's what the district court found.
My memory of Fisher 2 was that the Top 10% program was extremely successful at increasing the enrollment of underrepresented minorities at Texas. There are other solutions. We have a very sophisticated race-neutral alternative in this case that takes into account socioeconomic status and forces Harvard to eliminate its preferences for the largely white legacies. And that is another way. I mean, our numbers, the number of Asians would increase on campus, the number of Hispanics would increase on campus, the overall number of underrepresented minorities would increase on campus.
Blacks wouldn't increase.
Black representation would be 10%, which is higher than it is in the state of Massachusetts, and that number is quite low. Our expert testified that if Harvard was only willing to consider wealth instead of income, that number would be quite a bit better, because the main disparities we see on the basis of race today is not on parental income, but on generational wealth.
Justice Sotomayor?
I am a little bit concerned with your answer to Justice Kagan. You seem to suggest that a congressional clear statement rule could include something very plain statement rule, could include something indirect, like 2255 H says you can't have a successive petition on this issue, that would eliminate 2241 and that wouldn't create a constitutional problem. And by that I mean is someone who's completely innocent of the charge, given your wide definition of innocence, okay, there is no way to look at what they did as fitting the statutory terms that have now been described by this court. There's no inference that could be drawn from the evidence that they did it. They're completely innocent. You're suggesting that wouldn't create a Fifth and Eighth Amendment problem?
Well, first of all, Your Honor, I wouldn't say that that's a wide definition of innocence. But the other thing I would say
I'm
Sorry.
using the words of my colleague, Justice Gorsuch. I'm spotting you that. So I spotted for you and accept that, all right? But totally innocent under any definition you use.
Well, Your Honor, I don't think there's a problem with that here, because what we're talking about is whether Congress is required to give a further shot at collateral review in these circumstances. I think Felker against Turpin is quite clear that when it looked at the parallel limitations in 2244B, that Congress is free to statutorily alter the abuse of the writ, and I think by analogy the successive writ doctrines to preclude relief in these circumstances. I mean, these cases do have to reach conclusion at some point. And if Congress decides, and it's evident that it has decided, that look, you're just not going to be able to bring these kinds of claims anymore, then I think Congress's judgment is within its constitutional authority. Our point here is that Congress just hasn't made that judgment, and in fact, it's got this saving clause specifically just to make sure that whatever the federal habeas remedy would allow is still there, and that's the kind of claim that we're talking about here today.
Extraordinary. Okay. So almost any administrative process could be called collateral on constitutional issues, whether it's tax review as in Elgin or it's immigration issues. All of those petitioners are required to go through administrative processes despite the fact that most of those agencies can't reach constitutional issues. So I don't know what makes this situation different other than perhaps, and I'm not sure about this, the existence of the adjudicatory body, the fact that your removal clause challenge. But all of the other due process challenges seem to be the quintessential process-dependent claim. You can't get more intertwined than that. Your argument seems to be saying that any due process claim counts. What about the claim in the companion case Cochran that has been abandoned, that the SEC violated her due process rights by failing to follow its own rules and procedures? That's a classic due process claim that I think in almost every other agency action we wait until the end of the review process for the court to look at. So it seems to be that you're saying this is unfair because I have to go through the process. But going through the process is what due process is all about. I don't understand why you are any different than any other administrative agency petitioner who has to go through the process, a flawed process, and wait till the end to have that corrected.
So, Justice Sotomayor, with respect to due process claims in particular, I don't think we're arguing for a special rule for this particular agency. As I look at the court's cases, and they go all the way back to Matthews v. Eldridge and McNary, so this would apply in immigration cases as well, the distinction that the court has drawn is between cross-cutting due process claims that don't in any way depend on the circumstances of a particular case. So if you think essentially on its face that the statute doesn't provide due process, then that does seem like a claim that is wholly collateral to the merits of any particular.
But what about if you win? You don't care how you win, meaning once you're in a case, if you've been given inadequate process but you still win, you're going to suffer the litigation costs, et cetera, but it doesn't really matter what basis you win on.
Well,
this just gives you another hole in your pocket, another card in your pocket that you can play if you lose.
I don't think that's quite right, Justice Sotomayor, which is, this isn't a case like Elgin, where there's a review process for losing your federal job, and all the plaintiffs wanted was their federal job back. This is not a situation where all we want is to not have a cease and desist order.
Oh, it is, because your complaint asked the district court to enjoin the FTC and its commissioners from pursuing an administrative enforcement action. Your motion for a preliminary injunction asks for the same thing.
Absolutely, but
so it is tied to the proceeding very directly.
It's tied to the proceeding, but it's not tied to a cease and desist order in the same way as the challenge in Elgin. We believe that we suffer a here and now constitutional injury just from being subjected to an unconstitutional agency process with respect to the removal restrictions, and we think we suffer an injury the second that we are assigned to the FTC rather than the Justice Department and effectively denied any early access to court. Those are the claims we want to bring. They're not the claim that, like, we wanted to have 3 witnesses and we only got 2, and gee whiz, if the ALJ would have just given us 1 more witness, that would have satisfied due process. Those are the kind of claims that are not wholly collateral, and those are the kind of claims that belong in the administrative process.
But even in the context of putting in names...
I'm sorry, show me on your website. Show me on the pages of your petition for a writ of certiorari. Show me a page on that website that is an endorsement of a marriage as opposed to the story of a couple.
Well, either one violates the compelled speech doctrine.
No,
you
please
can't...
show me a page on your website. It's attached to your petition. I'll start you on page 51.
Pages 53, 52, 54,
okay,
55, and 56 all represent an invitation and a
53
celebration.
says our photo gallery. 54 says funny dating story. How is that your story, your photo gallery? It's the couple's photo gallery. Page 54 is funny dating story. It's their story, not your story. I'm looking at every page, and basically it's the story of the couple. It's a date on page 51. 52 is our special day. 53 is RSVP, our photo gallery. 54 is a funny dating story. I keep looking at all of the mock-ups, and all of them relate to what Lily and Luke are saying or doing, who they are, who are their grooms, who aren't who's their bridesmaids. I don't understand. How is this your story? It's their story.
If you're asking whether, first of all, book authors, newspaper editors, those who write all kinds of publications may be writing about someone else's story, but it's still their speech, and it's still protected.
They're not public accommodations in the same way.
Thank you. Justice Thomas? Justice Alito? Justice Sotomayor?
I take your answer to mean that there are no judicially enforceable standards to interpret the freedom of speech, freedom of assembly, and equal protection clauses of the Constitution, because they, on their face, would appear to be as unmanageable or broad, and yet we routinely let federal and state courts review those acts.
No, Your Honor, that's not our position at all. Our position is you need to look at the type of claim. So take equal protection. That's sweeping and capacious language. And if it's the type of claim where you're looking to assess whether race is the predominant motive or whether there's a violation of one person, one vote, there are judicially discoverable and manageable standards.
Some of them were created by the courts. But
yes, with judicially.
And so what's different than what the court did here in North Carolina, where it looked to the meaning of the English Bill of Rights of 1689, which apparently was the basis for the state's constitution, and it said that the meaning was to curb royal efforts to manipulate parliamentary elections. It then looked to other states that had read in the free election clause and other clauses of the state constitution to find that political gerrymandering violated this term. How is that any different than what we normally do in our review?
Nothing in the English Bill of Rights told the North Carolina Supreme Court whether an efficiency ratio of 6, 7, 8, 9, 10% was acceptable. There is no.
You're not answering my question. Absent the election clause, is this term so unmanageable that you're saying that the North Carolina court would not have power to determine what free election clause meant in their constitution?
They would be exercising legislative power. It's just like Rucho. This is the exact same issue that divided this court in Rucho, and for the same reason it was a violation of Article 3, namely there were no standards, there were no rules, and so it wasn't a case or controversy. So to here, it would be an act of legislative power for a court to make this determination.